Colorado's lease termination laws have undergone dramatic changes in recent years, transforming the state from a moderately landlord-friendly jurisdiction into one with significantly stronger tenant protections. If you manage rental property in Colorado, staying current on these changes is essential because the rules you may have followed 5 years ago have been substantially rewritten. The governing law is found in the Colorado Revised Statutes, Title 38, Article 12, the Security Deposits and Landlord Obligations Statute, along with the state's Forcible Entry and Detainer Statute in Title 13, Article 40. Let's start with no-cause termination. For month-to-month tenancies, Colorado requires the landlord to provide written notice before terminating. The notice period depends on how long the tenant has been in occupancy. Under recent reforms, landlords must provide at least 21 days' notice for tenancies of 1 month or more, but less than 1 year, and at least 28 days' notice for tenancies of 1 year or more. For tenants, the notice requirement is 21 days for tenancies of 1 month or more, but less than 6 months, and 28 days for tenancies of 6 months or more. These staggered notice periods were part of Colorado's recent legislative reforms aimed at giving longer-term tenants more stability and time to find alternative housing. The notice must be in writing and should be delivered by one of the methods authorized by statute: personal delivery, posting on the premises and mailing by first-class mail, or other methods specified in the lease. For fixed-term leases, the lease expires at the end of the agreed term. Colorado does not require additional notice at the natural expiration unless the lease specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the applicable notice period based on the tenant's total length of occupancy. For week-to-week tenancies, Colorado requires at least 3 days' notice from either party. Now let's cover termination for cause. And this is where Colorado's recent reforms have made the most significant impact. For non-payment of rent, Colorado's process has changed substantially. Under the reformed statute, the landlord must provide a 10-day notice to pay or quit before filing for eviction. This is a major change from the previous 3-day notice that Colorado landlords relied on for years. The 10-day notice must clearly state the amount of rent owed, must provide information about available rental assistance resources, and must be served properly. If the tenant pays the full amount within 10 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file a forcible entry and detainer action. The jump from 3 days to 10 days was one of the most significant changes in Colorado's recent reforms. Landlords who are accustomed to the old 3-day timeline need to adjust their processes and expectations. Filing before the full 10 days have elapsed will result in dismissal. Here's an important detail about Colorado's non-payment process. The state has strengthened the right of redemption. The tenant can pay the full amount owed, including rent, late fees, and court costs, at various points during the court proceedings and stop the eviction. Colorado's reforms expanded the circumstances under which the right of redemption can be exercised and limited the ability of landlords and courts to deny redemption. However, the right of redemption can be limited if the tenant has been through the non-payment process multiple times within a 12-month period. For lease violations other than non-payment, Colorado uses a notice-to-cure framework that depends on the nature of the violation. For curable violations, the landlord must provide written notice specifying the breach and giving the tenant a reasonable time to remedy the situation. Under the reformed statute, the notice period for most lease violations is at least 10 days. If the tenant cures within the notice period, the termination is voided. For repeated violations of the same type, Colorado allows the landlord to terminate without providing another opportunity to cure after the tenant has been given notice and cured the same violation previously. The specifics depend on the nature of the violation and the time frame. Landlords should document each violation and notice carefully to support an escalated termination if the behavior recurs. For serious violations, including criminal activity, drug-related offenses, and conduct that poses an immediate threat to health or safety, Colorado provides a shorter notice period. The landlord can issue a notice giving the tenant as few as 3 days to vacate when the violation involves substantial and imminent danger. This expedited timeline is reserved for genuinely dangerous situations and is not available for routine lease violations. Colorado has specific provisions addressing drug-related activity on rental property. If a tenant is involved in the manufacture, distribution, or use of controlled substances on the premises, the landlord can pursue eviction on an expedited basis. Colorado's history with both methamphetamine and the state's legalized marijuana market creates unique situations. While recreational marijuana is legal in Colorado, landlords can prohibit its use on their property through lease provisions, and violation of a no marijuana clause in the lease is a valid ground for termination. This marijuana distinction is important for Colorado landlords. The fact that marijuana is legal at the state level does not mean tenants have the right to grow or smoke it in your rental unit. Your lease can prohibit marijuana use on the premises, and if the tenant violates that provision, it's treated like any other lease violation. Many Colorado landlords include explicit marijuana clauses in their leases for precisely this reason. Colorado also enacted significant protections related to the eviction process itself. The state now requires landlords to include specific information in eviction filings, including documentation that the notice was properly served and that the required notice period was met. Courts scrutinize these requirements carefully, and deficiencies in the filing can result in dismissal. The eviction process in Colorado goes through the county court. The landlord files a forcible entry and detainer complaint after the applicable notice period has expired. The court issues a summons, and the tenant has a specified period to file a response. Colorado's court process includes mandatory opportunities for the tenant to answer and raise defenses before a hearing is scheduled. Colorado's reforms also introduced mandatory mediation programs in certain jurisdictions. In counties where these programs are available, landlords and tenants may be required to attempt mediation before the eviction case can proceed to trial. Mediation can add time to the process, but often results in negotiated outcomes that are more satisfactory to both parties. If the case proceeds to a hearing, both parties present evidence and the judge makes a ruling. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specified period to vacate. The court determines this period based on the circumstances and the grounds for eviction. If the tenant doesn't leave, the landlord requests a writ of restitution, and the sheriff carries out the physical eviction. The overall timeline from filing to removal in Colorado varies by county. In Denver, where the county court handles a high volume of eviction cases, the process can take 4 to 8 weeks for uncontested cases and significantly longer for contested cases. Denver also has additional local tenant protections and programs that can affect the timeline. In other Front Range counties, including Jefferson, Arapahoe, Adams, and El Paso, the timeline is generally similar but may vary based on local court calendars. In mountain communities and rural counties, the process may move differently based on court staffing and scheduling. Colorado has also strengthened its prohibition on retaliatory evictions through recent legislation. The state enacted expanded protections that make it more difficult for landlords to terminate tenancies or raise rent in response to tenants exercising their legal rights. The protections now explicitly cover a wide range of tenant activities, including reporting habitability issues, requesting repairs, contacting government agencies, organizing tenant groups, and exercising any right under the landlord-tenant statute. On the tenant side, Colorado provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Colorado habitability video, the tenant can provide notice and allow the landlord a reasonable time to make repairs. Colorado's warranty of habitability statute has been significantly strengthened in recent years, and tenants now have more powerful remedies when landlords fail to maintain their properties. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Colorado has multiple military installations, including Fort Carson, the United States Air Force Academy, Peterson Space Force Base, Schriever Space Force Base, and Buckley Space Force Base, making this provision relevant to a very large number of tenants in the state. Colorado provides comprehensive early termination rights for victims of domestic violence, sexual assault, stalking, and unlawful sexual behavior under Section 38-12-402. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protection order, a police report, or a written statement from a qualified professional, such as a domestic violence advocate, victim's advocate, or medical provider. The tenant must provide written notice at the time of or before termination. The landlord cannot charge early termination fees, and the tenant's liability is limited to 1 month's rent after the termination date. Colorado's domestic violence termination provision also includes a lock change right. The tenant can request that the landlord change the locks within 24 hours of the request. If the landlord doesn't comply within 24 hours, the tenant can change the locks themselves and provide a key to the landlord. The cost of the lock change can be charged to the tenant. Colorado also enacted protections for tenants who are victims of domestic violence in the eviction context. A landlord cannot evict a tenant based on the domestic violence itself, including police calls, disturbances, or property damage caused by the perpetrator. The victim tenant is protected from being held responsible for the abuser's conduct. Colorado also provides early termination rights for tenants who are victims of gas hazards, specifically carbon monoxide issues, when the landlord fails to address the danger within a reasonable time after notice. Colorado strictly prohibits self-help evictions. Under the Forcible Entry and Detainer statute, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. Colorado's recent reforms strengthened the penalties for self-help evictions, and tenants who are illegally locked out can recover actual damages, statutory penalties, and attorney's fees. Courts in Colorado take self-help evictions seriously, and landlords who engage in these tactics face both financial liability and potential contempt proceedings. One critical practical consideration for Colorado landlords: the pace of legislative change in the state has been remarkable. Colorado has enacted multiple tenant protection bills in recent legislative sessions, and additional reforms continue to be proposed and debated each year. What was legal 2 years ago may not be legal today, and what's legal today may change by next year. Landlords who operate in Colorado need to review their lease templates, notice procedures, and termination practices regularly to ensure they're current with the latest legal requirements. Working with a Colorado landlord-tenant attorney who stays on top of legislative changes is strongly recommended. Denver, Boulder, and several other Colorado cities have enacted their own local tenant protection ordinances that add requirements beyond state law. Denver's ordinance includes specific notice requirements, tenant right to cure provisions, and relocation assistance requirements in certain circumstances. Boulder has implemented additional protections as well. Landlords in these cities need to comply with both state law and local ordinances. Colorado requires landlords to return the security deposit within 1 month of the tenant vacating the property, or up to 60 days if the lease specifies the longer period. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit within the required period, they may be liable for treble the amount wrongfully withheld plus attorney's fees. Colorado's treble damages provision for security deposit violations is one of the harshest in the country and makes compliance essential. Colorado also prohibits excessive security deposits. The deposit amount must be reasonable, and while there's no specific statutory cap, courts can evaluate whether the amount charged was unreasonable. For the complete guide to Colorado lease termination laws, visit tenantscreeningbackgroundcheck.com. and subscribe to our channel for every state in our series.